Hi, everybody. This is Monty McIntyre, and welcome to Trial Alchemy. Now, today, my guest is Bob Vaage. He's been an attorney in San Diego for a number of years, started practicing in San Diego in 1984, and he has really worked with some of the premier attorneys in San Diego over the years. He started out working on the defense side with Mike Neal and John Rhodes at Rhodes, Hollywood, and Neal. He then worked with probably at the time the premier plaintiffs med mal attorney, Dan Broderick. And then after Dan was murdered, sadly, he went over and worked with another great firm, Thorsness, Bartolotta, McGuire, and Padilla. And since 1991, Bob has been practicing law with his own firm. And glad to have you with us here today. Now, let me tell you a little bit about his experience. Bob's been a member of ABOTA, the American Board of Trial Advocates, since 1994. And so that's really 10 years after he started practicing in San Diego. And he currently holds the rank of advocate, and he's tried more than 50 jury trials to verdict. He's received 8 outstanding trial lawyer awards from the Consumer Attorneys of San Diego, including Trial Lawyer of the Year. He's been listed in Best Lawyers in America for many years, and he was the Lawyer of the Year in California in 2017. He's been listed in Super Lawyers for many years, listed in Top 50 Lawyers in San Diego, and he's had total recoveries for clients. He does plaintiffs' work approaching or maybe exceeding $200 million. And his practice areas are the areas of plaintiffs' medical malpractice, product liability, medical fraud, personal injury cases involving major injuries, and wrongful deaths. So, Bob, without any further ado, welcome to Trial Alchemy, and I'm delighted that you're here today.
Thanks, Monty. I'm happy to be here.
So, Bob, you've tried a lot of cases over the years. What's one of your most satisfying trial victories?
You know, Monty, you asked me to think about that. I've actually got a couple that really come to mind and stand out. The first is a case called Catrosia versus Nuvasive, which was the first of these medical fraud cases that I've taken. It was actually probably one of the first in the country to go to trial. It was upheld on appeal. It basically involved an issue of a doctor at the University of California taking significant amounts of money from a medical product manufacturer and using a product in an off-label way without disclosing it to the client/patient. It also uncovered the fact that a lot of doctors, including this doctor, were not disclosing these outside income streams to the university as they were required. And so it was really the first case where I successfully pursued the doctor and the company for fraud by concealment. Got a good verdict, upheld on appeal. The second case that really comes to mind is Collins versus the County of San Diego. This is a case where I represented a young man who was arrested by sheriffs up in Encinitas, and they literally took him away from the paramedics who were about to take him to the hospital and took him to jail. He then fell twice in the Vista jail, hitting his head, wasn't taken to the hospital for 36 hours. There was some medical malpractice on top of that, which is how I originally got involved in the case, but backtracking, I brought actions against the county for the actions of the arresting officers and the jail nurses. And it really was the first big verdict in San Diego involving these jail abuse related issues that have now become much more common. Our pre-trial offer from the county was $500,000. We hit them for $12.5 million, which was upheld on appeal with a very conservative panel of the 4th DCA. The last one, just to mention, is I do a lot of Kaiser work, as you know. I took a Kaiser case for a brain-injured child that had been turned down by virtually every medical malpractice firm in the state. There were 65,000 pages of records. We took it with about 3 months before the statute ran, and I got an award, a verdict against Kaiser, which to my understanding is the largest ever against Kaiser, for $26 million.
Outstanding.
And the child who needed 24/7 care is now getting that, and the family's in a much better position. So those are three cases that come to mind.
Well, in that last example with that Kaiser case, I'm sure this is true with all of those cases for you. One of the things you got to worry about on the plaintiff side is, can you get enough of a recovery, whether it's a verdict, an award, or a settlement that'll provide for the care of this person for the rest of their life? I mean, that's a big concern, isn't it?
Oh, absolutely. I mean, at the end of the day, what we do is people who come to us with their cases, the outcome of that case is likely to be one of the most important things that ever happens to them outside of marriage or having a child. But with people who are severely injured, brain injured, particularly a brain injured child,
Right.
the outcome is going to be the single most important thing that will dictate how they're able to lead the rest of their life. And yeah, we take that very seriously.
Yeah, and especially with a brain injured child, and I've had those clients in the past. The parents are often the ones taking care of them, but as we know, mom and dad are probably not going to live long enough to take care of that child for their whole life. So it's really important for you to get something set up in place to help take care of them.
Absolutely.
Well, let's talk a little bit about trial preparation. I know you are somebody who works hard and prepares very hard. So I know you're probably getting ready for the case from the very beginning, but there's always a kind of a last stage prep time. I don't know whether for you it's a month or a couple of months or how long it is, but in that last final prep period, what is the way that you prepare for trial, and have you developed some routines or things that you've utilized over the years?
Well, sure, but like you say, we're preparing for trial from the day the case walks in our office. I mean, that's what we tell our clients when we take their case. We say your mindset should be the same as ours, which is your case is going to trial, and that should be the mindset. So I have it's not physical anymore; it's more electronic. But I have a trial notebook that I started keeping from the very beginning of the case, where I'm mulling over, these are the themes, these are the strengths, these are the weaknesses, these are the frames that I can use in the case. And as we go along in the case, I may be amending those things based upon the testimony of witnesses. Now, as we get closer to trial, obviously the key things are getting our client ready for trial. So we spend a lot of time getting our clients ready for trial. We put them through mock examinations. I spend time with them in their homes. I really think it's important with what I do, and for anybody who does what I do, that you really need to get to know the person that you're representing. So that's a key item as well. Then we're going through, the outlines of witnesses in the last couple of months and putting together outlines of examinations, either direct or cross, and we're building video segments from depositions that we anticipate that we may have to use to cross-examine witnesses. It's always really important if a witness gets on the stand that you're cross-examining and they say A, and you have them in deposition saying B, that you're able to call that up very quickly.
Right.
So that there's a lot of prep time involved with that. We also write out all of the information that we want to use in voir dire. And I may even practice my voir dire depending on when the last time was I was actually in voir dire and trial. And then I probably, because opening statement is so important, my staff kind of chuckles about a little bit about how many drafts of an opening statement is Bob going to go through. And I typically would say it's 25. And as I'm getting closer and closer, I'll actually videotape myself making an opening, so that I can look at it and look what my body language and facial expressions are like as I'm covering certain things. So those are kind of the things that we're doing as we're getting ready to trial. And obviously I'm thinking about how I can cull things down, and as time has gone on, as you know, Monty, attention spans are shorter, and the shorter and more
Yep.
crisp we can make our presentations, the better off our clients are going to be.
Yeah, and that's the hard work of being a good trial lawyer is you got to take a lot of information. You've got to find the important themes. You've got to distill it down to the essence and keep it simple, right?
The old KISS expression, keep it simple, stupid.
Yep, that's true. Say, in the last couple of years, we've had the emergence of artificial intelligence, and it's the rage of all kinds of people talking about it. Have you had any, have you used that in any way in getting prepared for trials in the recent years?
Well, what so far what we're using AI for is doing deposition summaries primarily.
Hmm.
It's actually pretty good at that. But being as compulsive as I am, I'll typically take those AI summaries and I'll go back through and make my own shorter summary from that. We use AI to draft letters. We may also use AI to draft legal documents. I'm still a little reluctant to do that. I basically tell my people the only problem with AI at this point in time in terms of legal documents is it'll make stuff up.
Yep,
And,
right.
and so the time you're saving in allowing AI to research and draft some sort of a legal document, you better use to make sure that everything that's cited is correct. Because the last thing you want to have happen is show up in court and have a judge say, this case citation doesn't exist. So that's where you have to be careful. So,
Right.
we want to use AI and we do use it, but we use it carefully.
That makes good sense. You don't want to be like that lawyer in the news last year who filed a brief with AI and had all these false sites.
Yeah, I mean, we've tested it, and it will make stuff up. And
Yeah.
at least the currently existing versions of this. Now, maybe that will eventually go away, but while I'm practicing law, I'm never going to allow artificial intelligence give legal quotations to cases or to statutes without double checking them to make sure that they're right.
Oh, yeah. And there's no way you want to file a brief without knowing your citations are correct. You're just not going to do that.
Well, I mean, you and I are old enough to remember shepherdizing cases in the law library.
That's true. Well, one of the things you touched on earlier, and this is an important thing in trials, is trial themes. And you've tried a lot of different kinds of cases, but what are some of the really successful themes that you've used when trying your cases to juries?
Well, there are some pretty standard ones that you can sub theme off of, and the stuff that I do. Uh, Trust, betrayal of trust, profits over patience, profits over safety. We one of the things I try to tell young lawyers is jurors not only want to know who, what, where, when, but most importantly, they want to know why.
Right.
And it should dovetail into something that they understand from their own life, which is money more important than safety, or do people put money before relationships, whatever it may be. But those are the oldest themes, right? Trust, betrayal,
Yep.
trust, and they apply in almost any kind of personal injury context, whether it's medical malpractice or product liability. Those are the really common ones.
They really do apply. Now, you've seen some outstanding defense lawyers in the work that you do, and what are some of the good themes or some of the best themes you've heard from your opponents?
Well, I mean, the best things that I see from defense lawyers are actually quite simple. One of which is I know you understand, and And a guy a lot of people in town know as a mediator, Tom Sharkey would be a classic example of this, which is be nice,
Yep.
uh, uh, kill people with kindness. Don't be the attack dog. The defense lawyers that I most respect and who are the most difficult to deal with in trial are the ones who are nice, polite to your client, reasonable, and so
Yep.
that's a generalization. Now,
Right.
with Tom Sharkey again as the analogy, a Boy Scout with a knife. Tom did know how to do things, but he did them politely,
Right.
and typically good defense lawyers will suggest that plaintiffs are overreaching or asking for a lot of money, but they do it politely. Or they'll point out that there may be some flaws in the plaintiff's testimony politely. Or they'll point out that the plaintiff's expert appears to make a lot of money from testifying and not necessarily from practicing medicine politely.
Right.
So I that's probably the overwhelming thing. The ones that are easiest to deal with are the ones who are just jerks in the courtroom.
Yeah. Well, being nice is important for the plaintiff's lawyer as for you and the defense lawyer. I mean, I remember in trying cases, my tactic or approach was nobody's ever going to out nice me. At worst, it'll be a draw and we'll be even. But there's a lot of times the other side acts like a jerk, and then you get the benefit of that, right?
Well, absolutely. I mean, and the same is true when you think about who are the best defense experts that I encounter.
Yeah.
Best defense experts that I encounter are the ones who are just well, first of all, well educated, but second of all, really nice.
Yeah.
And they'll concede the obvious, even though they may be making a concession your way.
Right.
It's those are the ones who are the most difficult to deal with and who make the best witnesses. I mean, I tell my own clients, and it's really true for anybody testifying in trial, how you say something is probably every bit as important of what you actually say.
Oh, yeah. I mean, you have to prepare your clients for the same reason, because if a jury thinks they're being a jerk and they don't like them, that's going to really hurt the plaintiff's side of the case.
I think one of the things that is not uncommon in my line of work is you spend a lot of time getting ready to cross-examine defendants and defense experts, and a lot of people don't spend enough time, one, getting to know their clients,
Yep.
and two, preparing them for deposition testimony and
Right.
preparing them for trial testimony.
Yep. Absolutely. Well, that's good information. So let's go on, and I like to ask everybody this question, and I want to hear your opinion on it. There's a lot of aspects to a jury trial. What do you think, in your experience, is the most important part of the jury trial, and why?
Well, it's actually two parts.
That's fine.
Voir dire and opening statement.
Okay.
And it's because we are tribal by nature, and people, as I think most people know and understand, that people want to take sides very quickly, either consciously or subconsciously. And then by the time my view is by the time you're through with opening statement, 80% of your job is probably over, because people, again, either consciously or subconsciously, have made decisions based upon their own knowledge, their own background, their own lives, applying what you've told them to those experiences. And then they will filter in the information and the evidence that's consistent with that view and filter out anything that isn't. So voir dire, obviously, you have to, people have to, by the time you get finished with voir dire, hopefully you've gotten rid of your real problems. That's about all you can really do in voir dire.
Right.
And you've established some rapport and some credibility with the jury. And you've also obviously talked about the strengths and the weaknesses of your case and prepared them for that information. And then going into opening statement, you're making that presentation, and now they have a feel for the case. And in my experience, 40 plus years of doing this, most people have made a decision. I mean, I think most people who really try cases would agree that the business about changing people's minds and closing argument is kind of a myth. And we can talk about closing if you want and how I feel about that. But I would add one more thing, Monty, that has come
Sure.
up in the last few years, and this is something I picked up from Mark Lanier, and I won't make a lot of recommendations, but if you have an opportunity to read anything Mark Lanier has written or go to any presentation that he makes, I think he's probably the greatest trial lawyer in the country of my generation.
Wow.
And he made a point at some that I in a meeting I had with him a few years back, which was he firmly believes that voir dire opening and your first witness are critical. That and it you shouldn't follow a formula. You shouldn't always like put the defendant on first. You should figure out who is the best witness to set your case and your themes off in the right direction. And it needs to be somebody that's bulletproof.
Right.
I always had a tendency to, like in medical malpractice cases, to call the doctor first under
Right.
776. But the problem with that is if you have somebody who's really good and who makes a good witness, then when you get done, defense counsel gets an opportunity to let him tell his story. And you don't necessarily want to do that. And
Not at the beginning of your case.
right. I mean,
Yeah.
and not to take too much time, but Lanier's example was, he tried the first of these big talc baby powder cases in St. Louis. And he was talking about what he did, which he had never done before, which was he showed a video of a deposition as his first witness. And the woman was a doctor who had been hired by Johnson & Johnson 35 years ago to test the baby powder. He tracked her down and he took her deposition, and he took about 5 minutes. He said, tell us who you are. The woman had a German accent. Tell us who you are. Tell us about your background. She was a researcher, a doctor, a pathologist, all of these things. And he said, were you hired by Johnson & Johnson? Yes. Were you hired to test the baby powder? Yes. When you tested the baby powder, what did you find? She said, I found asbestos.
Oh my goodness.
And he said, and did you put that in a report? Yes. Did you send that to the CEO of Johnson & Johnson? Yes, I did. No more questions. Now that case went on for 2 months, but the case is over.
That's a hell of a first witness.
Yeah. And so I tell you, I give a lot more thought to who my first witness is going to be now as a result of that, because I think he's right. That, you've made your opening, people are headed one direction or the other, then you can lock them in with that first witness, whoever it might be.
I think that advice from him is really good. I think you're right about that. You really want to start your presentation to keep that momentum going with whatever trust and whatever influence you built in your opening statement.
Exactly.
Absolutely. Boy, that's great suggestion. So, Bob, I think you've tried some cases since we've come out of COVID. And do you have any impressions about whether you think jurors are acting differently or the same? You have any thoughts on that?
I think just in general, and this not only comes from my experience, but from talking to other lawyers who've tried cases post-COVID, I think, and these are generalizations, obviously, but I think people, as a general proposition, are less trusting of authority, less trusting of government, which I think from a plaintiff standpoint, in terms of the kind of people you want on your panel, that inures to our benefit.
Right.
So that's again, just a general observation that I think has changed pre-COVID versus post-COVID.
Okay, great. in terms of getting prepared for trying a case, one thing that a lot of people do is they may use focus groups, they may do mock trials. I think focus groups are more common these days. Do you use either of those methods, and what do you use them for, and how do you find them beneficial?
I do use focus groups. There are a variety of different ways that you could do them.
Yep.
Literally do them on your own by recruiting people online. And you can obviously just, set them up in a conference room and, pay them $50 a piece and give them something to eat and, let them listen to the evidence. And then, you can videotape their deliberations and have them fill out a form. Or on the other end, you can use, I have a couple of jury consultants. I use one more than the others, and basically allow them to arrange it, and to kind of guide people through it and submit pre-screening questions, and it's just a lot more thorough. And again, you video their deliberations, and then the consultant will send you a report with thoughts about what they think will work, what won't work, things to be careful of. I personally think that if you're not doing that, you're making a mistake for any case that has a significant value, because of the fact, as we all know, when we work with a case and we live with a case, our view of it can become more partisan.
Right.
So the input from people, particularly people who are going to be like our jurors, about what they think is important, what they think is not important, and they see it from more of an independent perspective, I think is critically important. And for me, really very helpful, because it gives you a better way of looking at the facts, and shows you really where your strengths and weaknesses are, and they may not be the same as what you thought they were going into focus groups. So yeah, we do use them, and we find them to be helpful.
And when you do your focus groups, it sounds like you most of the time are also doing that with a jury consultant assisting you.
Most of the time, yeah. I mean, for example, one of the downsides of doing them on your own is, unless you have a neutral place where you can do it, the mere fact they're coming into your office,
Right.
they know which side you're on. And so, people will invariably tell you what they think you want to hear, as opposed to what you're actually thinking. So unless you have the ability to find some neutral space, that's an issue. The other thing is, if you recruit them online, again, they can go look online and look at who you are and what you do and so forth. So that makes it a little more difficult. Whereas if you're doing the focus groups with your consultant, when you
Right.
show up, they've never seen you before. They don't know what you're doing. And what we typically do is we tell them that we're lawyers that have been hired by people involved in the case to put on this focus group, that we have no dog in the fight, and that we're just in here presenting the information. And we
So
always
in your, yeah,
tell us what you really think, well, not what you think we want to hear.
yeah, that's good. So in your use of focus groups, are they most helpful for you in dealing with bad facts, finding themes, determining what's important that may be different from what you're thinking?
Yeah, I mean, all of the above, all the things you just mentioned. And again, you'll you'll be occasionally surprised. You'll actually, I mean, I've had this happen where a juror has a focus group person has raised an issue about a piece of evidence that you hadn't really considered. And
Right.
so you prepare for that, and then at the time of trial, it does turn out to be something that's important that you might not have realized, but for the fact that you did the focus group.
Right. That can be real important. Or sometimes I've heard of examples where the lawyers are worried about something and the focus group isn't so concerned about it. So you never know what they're going to tell you.
That does happen as well, no doubt.
Yeah.
And
Well,
along those lines, just before I forget, Monty, we will actually, if we can, we will actually show video from depositions of some of the key people to see how people viscerally respond to them.
and do you ask them how they felt about that witness?
Absolutely, yeah.
Yeah, that's really helpful. That gives you great info. So now we're getting close to the first day of trial, or we're at the first day of trial. Let's just jump into the voir dire portion. You've done your motions in limine and all that. So now with picking the jury, which is one of the most important things in your view, what are your thoughts on mini openings, and how do you use them, and how do you find them to be helpful on your cases?
I think many openings can be very helpful. Um, we do use them. But I will tell you that there are circumstances where, the jury consultant I use most frequently when we talk about doing a mini opening, given the factual circumstances of the case, he might say, I don't really think we need a mini opening here, and I'm concerned, given what we would be saying in the mini opening, that we might expose some jurors who would be favorable to us to the defense, and it will present them with an opportunity to challenge or remove people that we'd like to keep on the panel. And so we're going to pass on a mini opening in this case. That does happen, not a lot, but so most of the time we will do a mini opening, and then we ask people if they have any strong feelings about what was said, or they have any personal experiences with any of this, that kind of thing.
Right.
So I do think I would fall on the side of saying that most of the time they're helpful.
Okay. And so as a plaintiff's lawyer, and you only take a case if there are substantial damages involved, one of the things you're trying to do early on is find out which jurors may be most able to give you a fair verdict. So when do you first bring up the kinds of damages that may be involved in the case? Which part of voir dire or mini opening or opening statement do you bring that issue up?
Whichever comes first. It's, I mean, I bring it up right away. In voir dire, I may not bring that up as the first item to discuss, but I'll bring it up in the context. There are a lot of people who believe that that money damages shouldn't be awarded in cases like that. Have strong feelings about civil cases like this. They have strong feelings about damages for pain and suffering. And some people, what I'll typically say is, some people feel there should be a cap on general damages,
Right.
and other people think it should be up to the jury. And then I'll say, for example, does anybody here think that there ought to be a cap on general damages? Go show of hands. Somebody raise their hand. What do you think it should be? And I'll respond to that by saying, who else feels that way? And then if it's somebody I'm concerned about, I'll try to lock that in from the standpoint. I say, you're obviously a man or a woman who has strong beliefs. And can we agree? It doesn't matter what the law is. It doesn't matter what defense counsel says. It doesn't matter what the judge says. You're going to have a cap regardless of what the evidence is. Can we agree on that? If they say yes, then they're gone.
Right.
But yeah, I get a lot of motions in limine because I've been doing this for a while, saying, we don't want Mr. Vaage standing up and saying that he's going to ask the jury for $50 million. And my response to the court is to say, look, I have to be able to explore with people,
Right.
if they have a cap in their mind, a limitation on general damages, because then they can be challenged for cause. And I've never had a judge, even a difficult judge, disagree with that. So yeah, I do bring it up, and I bring it up right away. And some people just raise their hand and say, I don't think anything that happened to anybody is worth that amount of money. And then we get it, and I'll look right at them. I'll say, well, I hear you. I understand that. And I say, there are other cases in this courthouse, but it just seems to me like, because you feel that way, that this maybe might not be the best case for you, and my client's going to be starting off behind. Can we agree on that these are your feelings regardless of the law? And it's a much longer conversation, but I always tell people,
Right.
real goals of voir dire, in my experience, the people who are really good at it, is getting people challenged for cause.
Yeah.
And
If you can get,
you got to get that locked down before defense counsel gets up, before the judge intervenes. You got to get it locked down and confirmed that these are their beliefs. It doesn't matter what the law is, it doesn't matter anything else, and they're not going to change their mind. And your client is starting out behind. You got to get that locked in. So
wait,
I
and
hope
you're
that
right,
answers.
because
I hope.
if you don't lock it in, the defense counsel and the judge are going to open that door.
Well, absolutely right, and you've got a record. It doesn't matter what. Well, don't you think it can be fair? Yeah, it can be fair. It doesn't matter.
Yeah.
Got him on the record saying I can't be fair.
So in addition to talking about, caps and things like that, in your particular case, do you also ask the potential jury about damages in the range that you might ask them in closing argument, or that you may discuss in opening statement?
Well, I typically will say, look, depending on the evidence, I said, but I think there's a reasonable probability that when we get done with this case in argument, that that I may ask for $50 million. Anybody have any strong feelings about that one way or another? Anybody just think that's absolutely outrageous? It's absolutely absurd. Yeah, I don't like, at least for me, to say a number in my closing argument that I haven't already laid the groundwork for.
Right.
For me, I think that's problematic.
Yeah, I think it is. So you bring it up early. That's great. When you're picking the jury, do you have a jury consultant there usually that you're also working with in trial, or are you picking the jury by yourself?
Oh, no, no. I mean, I have a jury consultant, obviously, and I also have other experienced eyes in the courtroom, a couple anyways, because whether you're doing voir dire of 12 or 18 or 24 or whatever it may be, and there are other people in the audience, one of the things I see that I think is a real mistake, particularly with young jurors, is to use the old what the old John Wooden expression that Bill Walton quoted not too long ago, which is go fast but don't hurry.
Mm.
One of the problems that I see in voir dire is lawyer will ask a question of a juror, and while the juror is answering the question, the lawyer is already looking at the next person on the panel.
Yeah.
And not really hearing what the person has to say, which I think is a huge, huge mistake.
Big mistake.
So if I ask somebody a question, I'm going to continue, eye contact with them and listening to them until they feel they finish their answer. And then I may say something like, acknowledge it by saying, hey, I hear you. Now, if I'm asking an important question and somebody's, saying, I think what you do for a living is that that it shouldn't exist, and yada yada yada, and I'm listening, other people are watching to see if somebody else has a visceral reaction to that interchange, because I can't do that because I'm engaged with this person that I'm asking a question of. And and again, the other mistake I see people make is you don't argue with prospective jurors.
Right.
I mean, your whole job is getting them to talk. And if somebody says something, I think plaintiffs lawyers like you are the scum of the earth, and and this and that, I say, you know what? I hear you. And that's exactly what we want people to do. We want folks like you to tell us exactly how you feel. And I appreciate the fact that you've been so honest. Now, when I finish that, I'll say, now who else in this potential panel feels like Mr. So-and-so even a little bit. You know, and those hands go up. I know where I've got potential problems.
Right.
And we can, and I do that a lot. If somebody gives a bad answer like that, something that's problematic for me, I'll say, I hear you. I understand where you're coming from. I have relatives who feel that, whatever it is I might say. And then I'll say, I really very much appreciate it. Yeah. And then I'll say, who else feels like Mr. So-and-so? It's okay. It's okay if you do. Who else feels like Mr. So-and-so even a little bit?
Right.
Show of hands. I got people paying attention because I may not remember who they are, right? And I'll know that these are people I'm going to have to address with that, or I may go right to them and go around and find a way to get them all challenged for cause. So,
well, sometimes your judge is going to give you time limits on voir dire, but I would imagine with the questions you're asking, as you've just described, and then you're getting other hands raised from other people, I would suspect it's relatively rare the judge is going to try to cut you off because all that's useful information for cause.
Monty, honestly, I've never had it happen. I mean, and I'll give you an example. The last case that you watched me try last summer,
Yeah.
very well-known judge in town asked me, how long you think it's going to take us to pick a jury? He says, do you think we can get a jury picked in one day? And I said, what I always say, which is, I don't know. It depends on what people are saying. And
right.
I've had judges say, I want you to do it in this or that. Technically, under California law, they really can't do that. And what I'll tell them, it politely is, I can tell you exactly how long I'm going to be in my opening and in my closing and how long I'm going to be examining witnesses, but I can't tell you how long I'm going to be in voir dire until I stand up and start asking questions and hear what people have to say. And I'll say, now look, if I'm doing something you think I shouldn't be doing, you call me over to sidebar and tell me to knock it off or cut me off or do whatever you want. But if I'm gathering information, important information about the case, voir dire in my mind, and anybody who tries case is going to tell you, to all intents and purposes, it's probably over by the time you've picked your team. So,
yep, very true. So let's say you finished the voir dire, you've got your jury and your alternates. Now you're going to give your opening statement, which, as you said earlier, is the second most part of the most important thing, the voir dire and the opening statement together. What's your strategy and your approach to opening statement? I got to watch you do one last year. I thought you did a great job, but what's your strategy and approach?
Well, I typically try to start off by, giving a 1 or 2 sentence overview about the issues in the case. I mean, some people talk about safety rules and try to spill out things that people will understand, that they know from their own lives about that equal right and wrong. And then it's very common for me to say, now let me tell you the story of what happened in this case. For those of us who spend a lot of time reading, we understand that just using those words will typically get people's attention, because we naturally respond to stories.
Right.
And so it's not unusual for me. In fact, I almost always just say, now let me tell you the story of what happened in this case. And then I walk through it. And one of the points that I try to make, and this is something from Jerry Spence and the Spence Trial College, which is, if you're telling the story correctly, by the time you get to the really critical part, the jury should be almost predicting or seeing where this is going. You're getting them involved in that way.
Right.
So I work through it. I work through the facts. I talk to them about what the expert testimony is going to be, how it applies to the facts. I talk about some of the key law. And then one of the things I do that, and I would tell you, I'll tell people who wind up watching this, I have a reading list that I keep, that I use to give to people who want to try cases, books I think that they should read. And at the top of the list are the two books by a guy named Keith Mitnick, Don't Eat the Bruises. And he's really very practical. And one of the things he brings up, which I think is really critical, is he has a segment in his opening that I always use, which is, now let me tell you what the defense is going to say about this, and I'll tell you what my response is. So you walk through what you know they're going to say and respond to it. See, and what Mitnick likes to do is say, let me put that into context. That it's a generalization. Let me put it into context. And so I think people who don't do that create problems. The other thing that you absolutely have to do, and I've probably done it in voir dire already, but I'll certainly do it in opening, which is I will bring up any and all bad facts in my case.
Yep.
Because the last thing you want to have happen is you want to sit down from your opening statement and have defense counsel set up and say, wow, that was really great. And if that was all there was to this case, I'd suggest you give $1 million to Mr. Vaaghe's client. But unfortunately, Mr. Vaage left out a couple of key things. And let me tell you what those are. And you can ask yourself how important those things are in the context of what he just said. So, again, I don't know how it happens. But some lawyers just think if they, like people who aren't feeling well, figure if they don't go to the doctor, it'll just go away. I put this in the same category. It's like you think if you ignore your bad facts that they're just going to go away, they're not going to go away. It's probably why you're there in trial. So get them out there, get them out up front, get them out as soon as you can, and deal with it.
Well, if you don't do that, you lose credibility, and the other side gains tremendous credibility and momentum. You don't want to give them that gift.
Oh God, no. I mean, it's if the defense lawyer has a serious problem, I mean, I've probably brought it up, but if for some reason I haven't, and they don't bring it up in their opening, I'm going to try to get to that with a first witness or as quickly as I can.
Yeah. Yeah. Well, one of the things I ended up saying over time, and it sounds like you practice this in the kind of battle of a trial. I think the goal of a trial lawyer is to try to give no gifts to their opponent and to take advantage of any gifts their opponent gives them. And that's what you're trying to do. Not give a gift to your opponent by talking about bad facts first.
Absolutely. I think I told you this when we were talking about this. One of the things that always strikes me, and we talk about, trial by in limine now we, as opposed to 30 years ago, we see 50, 60 in limines from defense lawyers. and I typically, my oppositions are really short to those, which is, they're asking you to make a ruling in a vacuum. Let's get to the evidence presentation. They can object.
Yeah.
In limines are way overused, and most judges understand that, it becomes trial by in limine. And one of my favorite ones is, 352, it's prejudicial. Well, it's not what 352 says, first of all.
Right.
It says undue prejudice, significantly outweighing the relevance. And, this is, if a judge actually asks me, I say, Your Honor, if it wasn't prejudicial to the defense, I wouldn't be trying to get it into evidence.
Right. It's the old, it's hurt me, Your Honor. It's hurt me. Keep it up. Hey, you alluded to this earlier, and let's talk about this for a second. When you're impeaching witnesses at trial, I get the sense that you like to use video clips of their depots, but how do you like to impeach them?
Well, like I said, video clips are really important, and my approach is going to vary a little bit depending on the witness. And in the modern world, as opposed to the Stone Ages when you and I first started doing this, access to information is just much different. So you can gather, if somebody does a lot of testifying, you can gather 50 transcripts from them and pour through them and look for things that are inconsistent.
Right.
And so if there are some things that are inconsistent, you haven't advanced their deposition, you have to say, have you ever testified in a case with similar issues to this where you said something totally different? And so you have that in addition to anything from other depositions that you can use to impeach them can be very helpful, particularly with people who do a lot of testifying.
Yep.
Now, smart ones are smart enough to understand I can't say one thing in one case and then say something totally different in another case that's very similar. But
Yep.
people would be surprised, how many times I've actually had that happen. So not only am I doing video from their depositions, I'm checking their body of work. I'm also
Yep.
checking anything they've written. I'm also asking them in deposition, what publications or what text do you consider reliable?
Okay.
I'm laying the foundation for things I can cross-examine them with.
Right.
And then, the basic things in cross-examining an expert, it usually boils down to a few things. One is money, right?
Yep.
They're professional experts, or they've done a lot of work for the defense. They've never testified for plaintiffs. So they're prejudiced, right? Another is lack of foundation. And this is one that I love. Good defense lawyers don't make this mistake, but not giving an expert a couple of key pieces of information.
That's deadly.
Now, and again, my approach varies from one case to the next. If I think, by stabbing an expert in the heart in a deposition is going to get the case resolved, I'll do it. If I don't think it will, I may keep some things in my back pocket to use at trial. So a lack of foundation, or they don't have the expertise. These are the basic things, and you and I talked about this before. You can also use them to advance the story
Right.
that you're projecting just by the questions that you're asking. So again, so it varies from one expert to the next. It's not, for me, it's not one size fits all. And it also depends on, how good a witness they make.
Right. That makes good sense. So in doing your cross-examination of witness, it sounds like you may use different approaches at different times, either the classic closed approach where you're really trying to control them, not let them do much, or the open approach a la Jerry Spence, or our well-known in San Diego and unfortunately recently departed Milt Silverman, who is brilliant at it. So you use both of those styles of cross?
I do, yeah. And again, it depends on the witness. Some experts, you may ask them a closed-ended question and they use it to launch into a long explanation.
Yeah.
And, again, depending on the witness, depending on the circumstance of the case, how hard you push back on that is going to depend. And most of the time, if I think somebody's really doing that, I'll just say something, I really appreciate all that information, but I asked you a simple question. Can you answer it? So, again, how hard you push back depends on the quality of the testimony that they're offering. Some people you're not going to push back on very hard at all. Other people you're going to, because the jury's going to want you to.
Yeah.
You can push back hard.
Right.
So again, what we do for a living is every bit as much art as it is science. And you have to make adjustments, and depending on the witness, the circumstances of the case, how your jury's reacting, you have to pay attention to all of those things.
Yeah, it's not a one size fits all, and there's not just one way to do things. There's a lot of approaches, right?
Absolutely.
And you might do different things. So like with the open kind of across Jerry Spence Silverman style, what have you found that most useful to use that kind of approach with what kind of witness or situation?
Well, if I think, for example, well, one, if they make a good witness, if they're likable, and I know that they're smart enough to admit the factual information that's the basis for my story, that may be a circumstance where I'm using them to reinforce my storyline
Hmm,
without necessarily trying to make them look like they shouldn't be believed.
right.
And I may ultimately, say, well, and so are you telling this jury, given all that factual information, that you really don't think what happened here was wrong? And then I may say, may very politely say, now, can you remind me how much it is you're being paid to be here today?
Yeah, that's great.
So,
Well, let's go to the final argument. We're getting near the end, but I want to ask you a little bit about this. You're always going to have big cases with substantial damages, and one of the things that juries can have difficulty with is the non-economic damages, and those are probably often large in your cases. So what kind of information do you give them in closing argument to help them come up with a number in doing their deliberation? Because they're not really given any formulas and they don't know exactly how to do it. They haven't done it before. So what are the ways you help them?
um, well, for one thing, I talk about, uh, not what my client is going to get as a result of this case, but I talk about what they've lost, and
Yeah,
more likely to say what has been taken from them by the actions of the defendant. And I talk about things that people commonly understand and consider very, very important, which is um, independence, independence of movement, being able to get up and to go wherever they want, whenever they want. Um, um, uh, freedom, the freedom to do whatever it is you want to do on your own without needing the assistance of anybody else. Talk about loneliness. Because of these limitations, it's hard to interact with other people, to go places and interact with them. These are all things that people put right up at the top of things that are really important to them. And I talk about, like you say, they say there's no formula, use your common sense. There 12 people, think about the things we place values on in our society. We may pay $50 million to a ball player to play a children's game for the course of 1 year. Somebody may pay $500 million for a painting. What's the value? When you have to balance the amount of money with the harms and losses. And I will use scales like this. And then I do two things. I may break it down to a formula, because some people prefer a formula that they can look at. I can talk about $25 an hour, that it's a 24-hour a day, 7-day a week proposition with these injuries that they have to live with, that they've had to live with in the past 3 years and for the next 25 years going forward.
right.
And I'll just put that formula up and show what the number looks like. And then I'll say, other people, the law doesn't require it. You may just decide that even $5 million a year isn't equal to the harms and losses that this individual has suffered. Now, I also keep in mind that surveys typically show, and obviously it varies from one case to the next, but juries typically, in general damages, there are exceptions, obviously, and I've had these exceptions, but juries will typically award in a verdict about 25% to 1/3 of the general damages that a plaintiff's lawyer says. So I always keep that in mind, and I'll build a way to justify it into my closing. And like I said, I've probably said the number in my opening. Now, one of the things you have to be careful about, you may have heard this, Monty, is a term called anchoring.
Yep.
which is if you have $50,000 in medical expenses and $50,000 in income loss, and you're going to ask the jury for $25 million in general damages, you may want to waive those underlying economic damages, because
Right.
they will invariably anchor the verdict down.
Yep. Great advice. So we're near the end of our conversation. It goes fast, and it's always amazing how quickly it goes. But Bob, let's finish with this question, and that is, based upon your experience so far, what advice would you give somebody who wants to become an outstanding trial lawyer, whether it's advice you received when you were young or whether it's something you've learned along the years?
Well, the first piece of advice is something that would apply to almost anything, which is don't be afraid to fail. Don't be afraid of failure.
Yep.
And that's, it's human nature that we don't want to place ourselves at risk. We don't want to take chances. But, if you want to try cases, that's just inherent in what you do. So that's the first piece of advice is, don't be afraid of failure. If you want to get into this business, you're in the business of trying cases. Everything else is tied to that. And it's a longer conversation about why that is. But you're never going to get fair compensation for your clients unless you convince the people on the other side of your cases that you can and will try cases.
Yep.
So that's number one. Number two, in this day and age, as opposed to when you and I were starting out, when we could get small trials, absent that, go watch other people. Go watch other good trial lawyers, watch what they do. And, a lot of the things that we pick up over time is stuff that we've learned and picked up from something somebody else did in trial. And we make it
Right.
our own, and we make it our own. Now, you can't be Jerry Spence or Tom Sharkey. You have to adapt it to your own style. But there are tools that you can add to your toolbox by watching people. I think it's also a good idea, if you think you're going to go to trial, go watch the defense lawyers try a case. If you're going to be in a certain department, go down and watch the judge and watch how the judge handles their department. Now, all of these things are investments in time, but that, they're very well worth it. And you can go, I think, even though I didn't personally go, I think the Spence Trial College and other similar things are probably good experiences. I think Lanier, if you can go to a Lanier event, the guy I mentioned, Keith Mitnick, the books that he wrote, and he also does online things. I think he's very practical and really good. So just gather information from watching other people do these things, and then you got to get in the courtroom and you got to get on your feet. And you have to understand what that's like. And the last thing, again, that obviously we mentioned is preparation. Preparation is the key to success in what we do, trying cases, as it is in almost any other environment. One of my credos is I may lose a case, but I won't lose a case because the people on the other side are better prepared than me. And so that's if you think, and unfortunately I've seen this, and one of the advantages that I have over a lot of defense lawyers is, man, I've had cases where, my main goal is to punch them in the mouth in the first 2 days because they're just getting up to speed.
Right.
So if there is an advantage for what we do, it is that. So like anything else, preparation leads to success. But in this day and age where it's hard to find, if you can find a way to do pro per work, you get on
Do
a
it.
panel,
Yeah.
they'll give you a chance to do pro per work, whatever it may be, just getting in the courtroom and getting up on your feet. That's invaluable experience.
Well, I agree with you with everything you've said. Now, preparation, my little motto was, I may not be the smartest in the room, but nobody's going to out prepare me. And your
That's
example.
that's definitely true in my case, Monty. I'm never the smartest one in the room.
Well, another thing about don't be afraid to lose. I learned this lesson from your old boss, Mike Neal. I tried a plaintiff's med mal case years ago against Mike. he got a defense verdict and I was crushed. I thought it had merit. I would only take it, looking at it very carefully and all that, and I was crushed. But you know what happened? After that, the way he interacted with me was different. And I realized over the years, I said, damn, that loss actually paid benefits because Mike knew I was going to be ready. I was going to try the case. I was going to be prepared. And that makes a difference.
Yeah, I mean, like anything else in any other business, I mean, reputation develops itself.
Right.
And there are, unfortunately, a lot of people who claim to be trial lawyers who really aren't. And it's pretty easy for the insurance carriers and the defense lawyers to figure out who those people are. And if they realize that at the end of the day you're never going to try a case, you're never going to be able to get fair value for the poor people you represent.
When they know you won't try them, they're never going to give you the fair amount. Never will. Well, Bob, thanks so much for taking your time today. You've really shared a lot of great information that I know that people will love hearing. So thanks for all the great work you do for your clients and in the community. And thanks for being a wonderful guest today. Really appreciate it.
Yeah, Money, I enjoyed it and happy to do it. And, like I said, if anybody watching this has any questions about anything or about the books I'm recommending, they can reach out to me directly.
All right. Thanks so much.
Okay.